UPSC has a habit of asking questions where they will pick up certain terms from the constitution and ask you whether this particular term has been defined in the constitution or not. More often than not, these terms would not be defined in the constitution. Only and only the Lok Sabha can remove a council of. So I now arrive at one conclusion, that statement 2 is correct. Now once I know that statement 2 is correct, I will anyway arrive at the answer. So we know that there are certain exclusive powers that are enjoyed by Lok Sabha, there are certain exclusive powers that are enjoyed by Rajya Sabha in India. Which of the following is not a feature of Indian federalism? Another lesson to draw from this question is that always focus on what the question is asking. UPSC is not asking you define 75 clause 3 for me or what is there in 75 clause 3. They want you to understand the essence of 75 clause 3. You may have often heard the toppers telling you that you need to analyze previous year questions, especially if you want to do well in the prelims examination. It's important to understand the trends and take various lessons from previous year questions. But often when I discuss this with the students, they don't really know how they analyze the questions and what are the lessons that they can draw. So today I'm going to look at 7 previous year questions from the prelims examination from Polity section, and we'll try to understand what are some of the lessons that we can draw from that for the prelims of 2026 and beyond. So let's start. The first question that we have is a very interesting question that was asked by UPSC, which asks you to identify certain statements as correct or incorrect. The first statement is that the Parliament Prevention of Disqualification Act of 1959 exempts several posts from disqualification on the grounds of office of profit. The above mentioned act was amended 5 times, that is the Prevention of Disqualification Act of 1959, and the term office of profit is well defined in the Constitution of India. So we have to identify which of the following statements are correct. Firstly, if you have read the Parliament chapter properly, you would have realized that there are grounds for disqualification that have been provided for in our Constitution from the membership of the Parliament, or these grounds for disqualification would also apply to those people, those who are already the members of the Parliament. They have been mentioned in Article 102 of the Constitution. Specifically, if you look at Article 102 Clause 1, it tells us grounds for disqualification for continuing and for being a member of the Parliament. In that, the first ground that is mentioned is that if a person holds an office of profit. Now, the concept of office of profit actually came from Britain, where the idea was that how we can keep the legislature and the executive separate from each other as much as possible. And if the executive starts awarding positions to legislators in the government, then the overall independence of the legislature would be compromised, and its function to hold the executive accountable for its actions would also be compromised. There would be a conflict of interest. So therefore, the Constitution says that individuals, those who are holding any position in the government except that of the ministers, would be called as office of profit. And this would therefore lead to disqualification as well from the membership of the Parliament and the membership of the state legislature. But now the interesting thing is that when we adopted this concept into India from Britain, we did not really define the term office of profit in our Constitution. And this in itself is the first lesson that you need to draw from a question like this. UPSC has a habit of asking questions where they will pick up certain terms from the Constitution and ask you whether this particular term has been defined in the Constitution or not. More often than not, these terms would not be defined in the Constitution. The reason for that is because Constitution is a framework document. How can a framework document be including the definition of some of these terms, such as office of profit, or 2 years back, UPSC asked a question on the term efficiency in administration that has been mentioned in Article 335 of the Constitution. Do you even think that it is possible to define something like efficiency in administration? Do you think that it is even possible to define something like office of profit? Office of profit, broadly we can say that it refers to an office where a person is entitled to some kind of remuneration or benefit from the government as a result of holding that office, as a result of which that person's independence may be compromised as a legislator. But it's very difficult to specifically define what we understand by office of profit. So the point that I'm trying to make here is that the lesson that we need to learn from such questions is that UPSC has a habit of asking questions where they may ask you certain terms, and they may ask that whether these terms have been defined explicitly or they have been well defined in the constitution or not. And once you identify whether that particular statement is correct or not, then identifying whether the rest of the question is correct or not will become much easier, because the options in such questions are set in such a manner. For example, if I look at this particular question, let me forget about the first two statements. Let's say I do not know whether this act has been amended 5 times or 10 times or 100 times. I can't be sure of such facts of how many times a particular act has been amended, but I definitely know that the term office of profit is not defined in the Constitution of India, definitely not well defined. Once I am aware of that, I can eliminate option number 3, statement 3. And the moment I do that, I land up with the correct answer. Even though, as a serious candidate for the examination, I should know that the first statement is also correct. The Parliament Act exempts several posts from disqualification on the grounds of office of profit. Many of you must have heard of the Office of Profit Bill of 2006, which was returned by the President of India, Dr. APJ Abdul Kalam, back to the Parliament, because he believed that the provisions of the bill go against the morality of the Constitution and the basic intent of the Constitution of India. Now, if you relate it to that, then you would of course know that what was this act all about? This act included several positions where the holders of these positions were exempt from disqualification under the office of profit criteria. What the Parliament was trying to do was that it was trying to include various positions in this Office of Profit Act through a retrospective amendment, so that the various members of the Parliament whose membership was under a question mark could be saved from disqualification. Anyway, so the lesson that you need to learn from this kind of a question is that often there will be questions where UPSC will give you terms like contempt of court or minority or public order or defamation or reasonable restrictions or office of profit. These are not defined in the Constitution, and this is a very typical kind of a question that UPSC has been asking in the prelims examination in the last few years. So that's the first lesson that we need to learn. Now let's move on to the next question. Another interesting question: which of the following is or are the exclusive powers of the Lok Sabha in India? So we know that there are certain exclusive powers that are enjoyed by Lok Sabha. There are certain exclusive powers that are enjoyed by Rajya Sabha in India. Our attempt should be from this question to understand that UPSC tends to focus on those topics where there are certain exclusive powers of a particular institution or a constitutional authority. So now whenever I am reading polity next time, I need to focus on exclusive power of different institutions. There are certain exclusive powers that are enjoyed by the governor of a state, for example. Governor of a state can refer a bill that has been passed by the state legislature to the President of India for his assent. He can reserve a bill for the assent of the President of India. This is an exclusive power of the governor of a state. Similarly, this question is about the exclusive powers of the Lok Sabha. So let's look at the statements. To ratify the declaration of emergency. To ratify the declaration of emergency. If there is a declaration of emergency that has been made by the President of India according to provisions of Article 352, then ratification approval has to be given by the Lok Sabha alone. Is that true? We know that's not true. We know that this power rests with both the parliament houses because it has to be ratified by special majority of each of the houses of the parliament. So that's the first thing. So this first statement is wrong. To pass a motion of no confidence against the Council of Ministers. This indeed is an exclusive power of the Lok Sabha. Why? We need to know about the provisions of Article 75 Clause 3 of the Indian Constitution, which says that the Council of Ministers shall be collectively responsible to the House of People. There is no corresponding provision that has been provided for in the Constitution for the Rajya Sabha. Therefore, only and only the Lok Sabha can remove a Council of Ministers, because you continue to be in power as Council of Ministers as long as you enjoy the confidence of the Lok Sabha. So only the Lok Sabha can pass a resolution or can pass a no confidence motion against a particular Council of Ministers. So this is indeed an exclusive power. So I now arrive at one conclusion, that statement 2 is correct. Now once I know that statement 2 is correct, I will anyway arrive at the answer. See, these are some of the things that you need to notice. You can save a lot of your precious time in the examination hall if you, when you identify a particular statement as correct or incorrect, you may possibly end up with the answer on the basis of that statement alone, and you don't need to read the other statements. I'm not saying that you should not read the other statements, but in this particular case, simply by knowing that the second statement is correct, you will be able to arrive at the correct answer, because I already know the first statement is also wrong. I don't need to read the third statement, but let me still read the third statement, because there is no option that says 2 and 3 only correct. Anyway, third statement is to impeach the President of India. We all know, according to provisions of Article 61 of the Indian Constitution, President of India's impeachment can be carried out through a resolution passed by each of the houses of the Parliament by a majority of the 2/3 of the total membership of the House. So therefore, this is not an exclusive power of the Lok Sabha. Now, what is the lesson that I need to draw from here? That UPSC tends to focus on those areas where they want you to know what are the exclusive powers of Lok Sabha, what are the exclusive powers of the Rajya Sabha, as well as what are the provisions on which the Lok Sabha and the Rajya Sabha have equal powers as well. Now, let's move on to next question. The third question is that which of the following is not a feature of Indian federalism? Now, this question, the lesson that I want you to learn is that UPSC doesn't necessarily focus on definitions. See, UPSC is not asking you what is federalism. No. UPSC is not asking you in which provision of the Indian Constitution a mention of the federalism has been made. UPSC is asking you a very, very conceptual question, and that question is essentially about what is the true meaning of federalism? What is the philosophy behind federalism? We all know that federalism is a political system in which the powers are divided of the state at 2 levels of the government, in executive and legislative matters. And both the levels of the government are independent of each other. So this question is that only, which of the following is not a feature of Indian federalism? Another lesson to draw from this question is that always focus on what the question is asking. If you interpret this question as which of the following is a feature of federalism, then you'll be in trouble. Because the question is which of the following is not a feature of federalism. Let's look at these statements. There is an independent judiciary in India. This is indeed a feature of federalism. Because if there would not be an independent judiciary, then how would it be able to resolve the disputes that may occur between the 2 levels of the government in an impartial manner? Second, powers have been clearly divided between the center and the states. This is also a feature of federalism. In fact, this is the chief characteristic of any federal polity. The federating units have been given unequal representation in the Rajya Sabha. So now, this is not an essential feature of federalism. In India, Rajya Sabha states have been given unequal representation. Whether states should have equal representation like USA in Council of States or unequal representation in Council of States is not an essential feature of federalism, but in case of India, it is indeed a feature of our federalism. So you have to notice this as well. Question is not which of the following is not a feature of federalism. It is a question about which of the following is not a feature of Indian federalism. It's about Indian federalism, not federalism in general. The fourth is it is the result of an agreement among the federating units. This we know is definitely incorrect, because when we read Article 1 of the Indian Constitution, we come across the fact that India is a union of states. India is not a federation of states, which means that India has not been formed as a result of an agreement between the states. Rather, this political sovereignty of India was divided between the union and the states according to the Indian Constitution. That also tells us a very important fact for questions like these, that UPSC is not just trying to check you on basic concept of federalism itself, but also trying to judge your understanding of various other concepts that you may have read in different parts of the syllabus. Now, let's move on to another question. If a particular area is brought under 5th schedule of the Constitution of India, which of the following statement best reflects the consequence of it? So we all know that there are Schedule 5 areas in the country. If a particular area is declared by the President of India to be brought under Schedule 5 of the Constitution, then what is the consequence of it? It best reflects the consequence of that area being brought under Schedule 5. This would prevent the transfer of land of tribal people to non-tribal people. It would prevent the transfer of land of tribal people to non-tribal people. It seems correct to me, because here we first need to know why Schedule 5 was introduced in the Constitution. During the colonial times and before, the scheduled tribes in India were subject to exploitation by the outsiders. You must have read in your history books how the land of the tribals was taken away by the outsiders, how the activity of the money lending was not under control and regulation, and as a result of that, exorbitant rate of interest were charged from the tribal and their land was usurped by the money lenders. How the various customs, traditions of the tribal community were compromised or were diluted as a result of enforcement of alien laws to them. These were the reasons because of which we wanted to provide protection to the tribals in India. And that's why we included Schedule 5 as a special protection for the tribal communities in India. So the second statement is, this would prevent the transfer of land of tribal people to non-tribal people. This would create a local self-governing body in that area. See, there is no doubt that creation of Schedule 5 of the Indian Constitution would set up something called as a Tribal Advisory Council. But it is only an advisory council. It's an advisory body. It is not supposed to be providing local governance in that particular area. The major powers in case of Schedule 5 areas remain with the governor of the state to make regulations on the advice of the Tribal Advisory Council. So this doesn't seem correct, and this we have to find the most appropriate option. So the lesson to understand from this question is that UPSC often gives questions where a particular statement may not be outrightly incorrect, but they are looking for the best statement, the most appropriate answer. Third one is, this would convert that area into a union territory. Of course, creation of an area into Schedule 5 or putting it under Schedule 5 does not convert it into a union territory. We know that the process for that exists under Article 3 of the Indian Constitution. The state having such areas would be declared as special category state. That is also not true. Special category status is something which is completely different and out of the constitutional scheme, and this is the mechanism which was created by the Planning Commission in order to provide special assistance to those states which have a certain peculiar position in Indian federalism. The point that I'm trying to make here is that, again, see, UPSC's attempt is to judge whether you understand why 5th schedule of Indian Constitution was enacted. UPSC expects you to know what was the rationale behind inclusion of 5th schedule in the Indian Constitution. Once you understand that, then answering this question becomes very easy. The major reason for enactment of Schedule 5 of the Indian Constitution was protection of tribal land. It was to provide self-governance to the tribals, but through the powers of the governor. The idea was to prevent the alienation of land from the tribals to non-tribals, to regulate the activity of money lending, which had proven as an exploitative activity in the past. Those are some of the things that we need to be aware of. And that's why it's very important that in polity you are able to relate concepts from history, from sociology, from society into polity. And then your understanding of the subject will be far more superior as compared to the other candidates. You see, in 2013 in mains examination, UPSC asked a very beautiful question in internal security paper 3. Analyze the impact of non-implementation of provisions of Article 244, which is essentially related to Schedule 5, on the rise of Naxalism in India. Here they are trying to again judge that whether you understand that one of the big reasons for the rise of Naxalism in India has been tribal grievances due to alienation of their land or exploitation by moneylenders and outsiders, and how this could have been prevented had we implemented the provisions of Schedule 5 of the Indian Constitution in all honesty. But since we have not done that, there are certain challenges that exist with respect to that. Anyway, so I hope you learn that here UPSC's attempt is again not what is there in fifth schedule, etc. But it wants you to understand the intention. It wants you to understand the basic premise on which the fifth schedule of the Indian Constitution was enacted. Let's look at another question. Very beautiful question that was asked by UPSC. A parliamentary system is one in which of the following comes into picture? Here again, UPSC is not asking you for what is Article 75 Clause 3. UPSC is not asking you for defining parliamentary government. You should understand what is the essence of parliamentary government. Essence of parliamentary government is enshrined in Article 75 Clause 3. That you can hold the government or you can hold the power as executive only as long as the parliament wants you to hold that power. That's not the case in presidential system. Once you are elected as president of the United States of America, you continue to hold the office for 4 years until unless you are impeached from that office. It does not matter whether your party has majority in the Senate or in the House of Representatives in America or not. But in India, it does matter. If you have to continue as Prime Minister or Chief Minister of a state, then in that case, you need to have majority in the directly elected house, in House of People or in the Legislative Assembly of the state. So therefore, let's look at the statements. All the political parties in parliament are represented in the government. That's not true. It's not necessary. It's possible that political parties may not win any seats and they may not be having any kind of representation, one, in the legislature and secondly in the government. Why should all the political parties be sitting in the government? There will be some opposition as well. Second, the government is responsible to the parliament and can be removed by it. This is the chief essence of a parliamentary form of government as enshrined in Article 75 Clause 3. But again, notice, UPSC is not asking you define 75 Clause 3 for me or what is there in 75 Clause 3. They want you to understand the essence of 75 Clause 3. They want you to understand the essence of the provision of the Constitution and then they will apply that in a question. The government is elected by people and can be removed by them. Well, yes, the government is elected by the people, but firstly, not directly in parliamentary form of government. And secondly, government cannot be really removed by people until and unless the House of People loses confidence in the government in parliamentary form of government. And the government is chosen by parliament but cannot be removed by it before completion of a fixed term. This is definitely not true. We know that there have been so many premature governments in India, those who have been dislodged from power because they lost majority in the Lok Sabha or in the House of People. So I hope you again understand the lesson to be drawn here is that do not necessarily try to rote learn articles. Try to understand the premise behind them. Try to understand the philosophy behind them and then you will be doing much better in such questions. Anyway, let's look at another question. Pursuant to the report, so we have to again identify the correct statement. Pursuant to the report of H.N. Sanyal Committee, the Contempt of Courts Act of 1971 was passed. When I'm sitting there in the examination hall, it will be very difficult for me to tell when was this H.N. Sanyal Committee formed? Was it the one that recommended Contempt of Courts Act of 1971 to be passed and so on and so forth? I was not even born at that point of time. How can I be judging whether this statement is correct or not? But let's look at other statements. This is also another lesson that you need to draw. Often questions will come in the examination where there will be one or two statements which will be very difficult and absurd and you will have no clue about it. But that doesn't mean that you will not be able to arrive at the right answer if you apply common sense and if you continue to have faith and belief in your concepts and in your preparation. So let's see. Second says that the Constitution of India empowers the Supreme Court and the High Courts to punish for contempt of themselves. Does the Constitution of India empower the Supreme Court and the High Courts in India to punish for the contempt of the Supreme Court and the High Courts? Yes, we do know this. If you look at the provisions of Article 129 of the Indian Constitution, if you look at the provisions of Article 217 of the Indian Constitution, indeed, this is being mentioned in the Indian Constitution. So I know that this is true. 129 and 225, if I'm not wrong. Anyway, so the Constitution of India defines civil contempt and criminal contempt. You remember, I was telling you in the first question that they tend to have this habit of putting statements and asking you whether this term has been defined in the Constitution or not. How can a term like criminal contempt be defined in the Constitution? How can a term like civil contempt be defined? See, contempt means disrespect. What constitutes disrespect of the court? And in which case it would become a criminal case or a civil case? Isn't this very complicated matter to be decided in the Constitution, which is the framework law? So therefore, this is definitely not defined. Now, see, if I identify that the third statement is wrong, then I can arrive at one conclusion safely, that 1 is definitely correct. 2 is also correct. Now I have to see whether 4th is correct or not. So the entire question now is dependent on 4th. In India, the Parliament is vested with the powers to make laws on contempt of court. This is a tricky statement. This is a difficult statement to know the answer to, until and unless when you were reading the provisions of Article 19(1)(a) of the Indian Constitution, read along with Article 19(2), you have paid some attention to contempt of court as well as a ground that is mentioned in Article 19(2). This brings me to another important point. Whenever you are studying polity, do not treat the topics in silos. Always try to prepare topics in a very comprehensive manner. तो अगर मैं आर्टिकल 19(1)(a) पढ़ रहा हूं, तो मेरे को 19(2) के अंदर क्या रिस्ट्रिक्शंस हैं वो पता होनी चाहिए, और उन रिस्ट्रिक्शंस में उन रिस्ट्रिक्शंस का क्या मतलब है, कंटेम्प्ट ऑफ कोर्ट का क्या मतलब है, डेफेमेशन का क्या मतलब है, मोरालिटी एंड डिसेंसी का क्या मतलब है, इसके क्या पर्सपेक्टिव्स हैं थोड़े बहुत, those basic things I should know. And then I would definitely know that there is a law which has been enacted by the Parliament of India called as the Contempt of Courts Act of 1971, and this particular law was enacted by the Parliament. So now the answer I know is definitely 1, 2 and 4, and the third statement is definitely incorrect because this term is not been defined in the Constitution. Now let's look at one more question. Which of the following are not necessarily the consequences of proclamation of president's rule in a state? This is also a trend that you need to notice. UPSC tends to ask questions on what is necessarily going to happen as a result of something being done and what is not going to happen, what is possibly an option. For example, they may ask question related to the devolution of powers to the panchayats and municipalities in India. Is it necessary for the state legislatures to make a law and to give powers on various functions mentioned in Schedule 11 or Schedule 2 to the panchayats and to the municipalities in India? The answer is no. It is optional to a large extent. So it's important that you pay attention to, when you are reading provisions of the Constitution, what will be the automatic consequence, what is something which is optional, discretionary, and what is something that is possibly the outcome of the same. We need to prepare topics like that. So अगर हम इस question को देखें, it says that जब president rule लगता है किसी state में, basically article 356 of the Constitution, तो what happens automatically as a result of that? Dissolution of legislative state assembly. Dissolution of legislative state assembly does not happen automatically. Only thing that happens is, as we know under article 356 clause 1, the administrative machinery of the state is overtaken by the President of India or by the Union government, and the State Council of Ministers gets dismissed, and the executive powers of the state are supposed to be carried out by the President of India or through an authority. But dissolution of legislative assembly is supposed to be carried out as per an order issued by the governor of the state under his executive powers, which means that now this power will be exercised by the President of India. This is not an automatic consequence of the same, of invoking article 356 or removal of Council of Ministers in the state. This is definitely automatic. It leads to removal of Council of Ministers in the state. And third, dissolution of local bodies. What have local bodies got to do with the enforcement of the president's rule in the state. So which of the following are not necessarily the consequences? The question, not the question is not which of the following are necessarily the consequences. Which of the following are not necessarily the consequences? So one is not definitely a consequence. Second is definitely a consequence. There will be dissolution, removal of council of ministers in the state. This is definitely going to happen. First is definitely not going to happen, is not necessary, it may happen. Third, dissolution of local bodies. This is again something which is a power that is supposed to be exercised depending upon the law that exists in the state by the governor of the state. That may or may not happen. So therefore the answer to this question is going to be 1 and 3. The key takeaway to keep in mind is that whenever you are reading topics like Article 352, 356, 360, always classify the consequences into automatic consequences. What are the discretionary consequences, like dissolution of assembly, and whether the dissolution of the local governments, etc., can take place, and then in some cases no consequences at all. For example, I know that local bodies do not necessarily get affected as a result of invoking the provisions of Article 356 of the Constitution. So what are some of the lessons that we have learned from analyzing just these 7 questions? UPSC more or less tests your concepts and not just article numbers or basic definitions, especially in the prelims examination. Second, and a very important thing is, it's important for you to know what is optional, what is possible, and what is definitely going to happen as a result of certain provisions of the Indian Constitution being invoked. Try to use logic in order to eliminate wrong options. This is very important because in prelims examination, the examiner will often try to confuse you with and overload you with a lot of concepts and with a lot of statements and a lot of junk information. You need to know how to eliminate those particular statements, and for that common sense and logic really helps a lot. Then understand the interlinkages between various topics. Understand linkage between history of tribals and the reasons why Schedule 5 of the Indian Constitution was brought into force, and so on and so forth. Grasp the core logic of the concepts like Schedule 5, grasp the core concept of federalism, grasp the core concept of parliamentary democracy, and also specifically certain aspects like no confidence motion or parliamentary accountability, etc., are very important, and that is something which you should not be missing. And कई बार जानबूझ के यूपीएससी कुछ क्वेश्चंस में faulty assumptions डालती है. It's very important to avoid those particular traps as well. So I hope that just with the help of these 7 questions, you may have understood the approach that you need to have while solving the prelims paper and solving previous year questions, and how you can analyze and learn from some of the previous year questions. I hope you found this pretty useful. In our future classes as well, I will keep coming up with such ideas in the class so that you can become more equipped to do well in the prelims. Okay, so thank you so much.